Welcome to this explainer. Today, we're diving into a remarkably brief, yet honestly incredibly fascinating single-page constitutional court judgment out of South Africa. It's case CCT 33/00, and it brilliantly pits our highest constitutional rights against the gritty, everyday reality of bureaucratic paperwork. Whether you're a legal eagle or just kind of curious about what happens behind the scenes in the justice system, this case is a perfect snapshot of what happens when lofty ideals hit administrative roadblocks.
Okay, so let's jump right into this legal mystery. I want to start with a question that really gets to the absolute heart of fairness. What happens when the justice system itself delays your appeal? I mean, we usually think of the courts as these swift arbiters of justice, right? But what's your recourse when the actual machinery of the court is the exact thing putting your life on hold? It's a wildly frustrating scenario, and well, it's exactly the predicament our applicant found himself in.
Now, before we get into the specific facts of the case, we really need to nail down the exact right at the center of this whole controversy: the right to a speedy trial. Basically, it's a constitutional guarantee that an accused person's case will be heard and resolved without any unreasonable delays. And this isn't just dry legal jargon, folks. This is a crucial protection against being stuck in legal limbo. It literally ensures that people don't just languish under the shadow of a conviction indefinitely. It is an absolute pillar of a fair system.
Section 1. A law student's conviction.
Let's roll back to the beginning of our story and see how this whole conflict blew up in the lower courts. And the irony here? It's pretty sharp. Our applicant, Sonny Boy Edward Saane, well, he wasn't just your average citizen navigating the courts. He was actually a law student at the University of South Africa, or UNISA, and he was facing a charge of corruption in the Johannesburg Magistrates Court. Because he was studying the law, Saane intimately knew his constitutional rights, which, as you can imagine, seriously raised the stakes of his complaint. He knew exactly what the system was supposed to be delivering.
2 years. That's 2 years. That was the harsh reality for Saane. Despite his legal background, the trial court handed down a conviction, and he received a sentence of 2 years imprisonment for that corruption charge. Now, a 2-year sentence is a heavy blow for anyone, but especially for a law student whose entire future career basically depends on having a clean record. So naturally, he decided to fight it.
Section 2. The speedy trial dilemma.
All right, so with the convictions secured and the stakes set, we enter the next phase of this explainer where the legal gears just seemingly grind to a complete and total halt. The dates here really tell the whole story, so let's walk through them. Saane was sentenced on September 27, 1999. Just 3 days later, on September 30, boom, he is swiftly granted leave to appeal to the High Court. So far, so good, right? But then, crickets. Notice how months and months just drag by. Fall turns to winter, winter into spring, and by July 6, 2000, his appeal still hasn't even been set down for a hearing in the High Court. Completely fed up with this massive gap, Saane takes a desperate leap and applies directly to the Constitutional Court. Frustrated by the crazy wait, Saane just completely bypassed the High Court. He basically threw the book at the system. He claimed there was procedural unfairness in his initial trial, substantive errors in the magistrate's actual decision, and, most importantly for us today, a complete denial of his right to a speedy trial. He was essentially arguing, hey, the system is failing me so badly that the highest court in the land literally needs to intervene right now.
Section 3. Investigating the delay.
So how does the highest court in the land actually handle a direct complaint about a delay coming from a much lower court? Well, this chain of events is a perfect display of the justice system's strict hierarchy in action. When Zakone's application landed on their desks, the Constitutional Court didn't just sit around guessing what went wrong. The president of the Constitutional Court personally requested an inquiry. This immediately prompted the director of the Constitutional Court to make formal inquiries directly down the chain, straight to the clerk of the Magistrates Court, to uncover exactly why this law student's appeal was stuck in the mud. It is a really fascinating look at top-down accountability.
Section 4. The 1296-page problem. This top-down investigation quickly yielded an answer, and it brings us to the logistical climax of our explainer, 1,296. As it turns out, the culprit delaying Saane's constitutional rights wasn't some malicious state conspiracy. It wasn't a judge holding a vendetta, it was just a massive physical mountain of paperwork. Specifically, the trial record spanned exactly 1,296 pages.
And right here is where the lofty, abstract ideal of a speedy trial crashes headfirst into the super mundane, bureaucratic reality of clerical work. The entire delay happened simply because the clerk's office needed time to prepare a corrected, proofread copy of this sprawling 1,296-page trial record just so it could be sent over to the High Court. Justice, in this specific case, was literally moving at the speed of a typewriter.
But, the inquiry did bring some good news. The clerk confirmed to the Constitutional Court that the bureaucratic logjam had, finally, cleared up. The corrected record had officially been lodged with the High Court, and a date for the appeal would be set very soon. And, crucially, the applicant was currently out on bail. Now, this is a vital detail, because being out on bail heavily mitigates the immediate, tangible harm of that massive delay. He wasn't sitting in a prison cell waiting for paperwork to be typed up, he was at least out in the world.
Section 5. The Court's Final Verdict. All right, so with the mystery of the delay solved and the paperwork finally filed away, Justice Sachs and the Constitutional Court had to deliver their final ruling on Saane's application to just bypass the system. They really had to weigh their unique role against the proper everyday function of the High Court. See, the High Court is the pending, appropriate venue that is completely capable of hearing all of Saane's issues, whether it's the factual disputes about the corruption charge or the legal disputes about his trial. Because the High Court was now finally equipped with that massive 1,296-page record and was actually ready to do its job, jumping the queue straight to the Constitutional Court was no longer justified. The Constitutional Court is definitely not meant to be a shortcut for standard appeals, even when there's been a wildly frustrating delay.
With swift, totally impartial logic, Justice Sachs delivered the final blow to Saane's procedural shortcut. He concluded, and I quote, "His application for leave to appeal directly to this court is accordingly refused." Ultimately, the system, even though it was agonizingly slow, was finally working as intended. So the Constitutional Court formally instructed Saane to just let the standard High Court process play out.
And here's the thing. This wasn't just Justice Sachs going rogue. There was absolute 100% consensus on the bench. All 10 other justices, from President Chaskelson all the way down to Acting Justice Madlanga, fully concurred with Justice Sachs's judgment. 0 dissenting opinions. It was a completely unanimous agreement that closed the book on this constitutional shortcut, and it really reinforces that procedural hierarchy matters just as much as individual rights. As we wrap up this explainer today, I want to leave you with one final thought to mull over. Where exactly is the line between our demand for swift constitutional justice and the completely unavoidable 1,296-page realities of legal bureaucracy? Sonny Boy Saane's case forces us to realize that the justice system isn't just made of lofty ideals and wooden gavels. It's made of paper and clerks and time. So how much delay is acceptable when simple human logistics are involved? It's definitely a fascinating question about how our constitutional rights actually function in the real paper-heavy world. Thanks for joining me to explore this case, and definitely keep questioning how the system works behind the scenes.